Good afternoon, everyone. Can you hear me? You can type in the chat. Can I please ask all of you to be mute? Okay, very good. Mute your microphones, please, everyone. Okay, I can see everyone is hearing well. Very good. So thank you for being with us. Thank you to our guests for being with us, and also to the participants to this online symposium for being with us. It's a new format for us, so we are happy to try it. We are sorry that you couldn't be with us here today, but due to the circumstances, we had no other choice. So we hope that the format will be suitable for educational purposes. So it's a real pleasure to have all of us, or all of you, here with us to celebrate together the 60th anniversary of the Republic of Cyprus by focusing on some aspects of the state of affairs that have contributed to the establishment of the Republic of Cyprus in 1960. So each speaker will develop one aspect of the state of affairs, and I will introduce them in turn. Let me also say that we are here celebrating the 4th visit by the Honorary Mr. Justice Kostas Kleridis of his honorary doctorate by the University of Central Lancashire, in recognition of his significant contribution to society, to higher education, and to the discipline of law. So thank you very much, Mr. Kleridis, for being here with us. In view of the ongoing COVID-19 pandemic, the conferral of the honorary doctorate will be delayed for the foreseeable future. This is why we are here tonight, to get a chance to actually listen to you. In the meantime, the University, European Cyprus, would like to place on record the twin facts that a decision has been made to bestow this honorary doctorate upon you, and also that you have graciously accepted it. So thank you for this. Before I may pass on the floor to the Honorary Judge George Arestis for his welcome address, I would like to please remind you all that this is an online symposium. It is recorded for the purpose of widening access to educational resources, such as this symposium. So if you have not returned yet the consent form which was sent to you, please do so in due course. I would like to please ask you to keep your cameras and your microphones off at all times, and to use the chat function in the MS Teams classroom to ask questions or make comments. We will monitor the chat function. If you do not wish to appear at all on the recordings, then do not use the chat function either. So now it's time to listen to our welcome address by Mr. George Arestis. So just a second, bear with us. We will move the microphone to Mr. Arestis. Thank you. I'll take it if you have to come first. Thank you, Zora. Thanks.
Dear speakers, dear participants, good evening to everyone. After a 4-year armed struggle fought by the Greek Cypriot majority in order to get rid of the colonial rule and achieve enosis with Greece, Cyprus became independent in 1960. The Turkish Cypriot minority was not only against the idea of enosis, but it collaborated with the colonial government against the Greek Cypriot struggle, aspiring at the same time to the idea of partition of the island. Independence, therefore, was the result of a compromise to avoid both enosis and partition. The constitution on which the new state was established reflected this bitter compromise. It was a constitution imposed on the Cypriots by the three guarantor powers and not approved by the people. The seeds of the division were already entrenched in the constitution. In spite of the fact that a system of checks and balances was established in order to protect the rights and freedoms of each community vis-à-vis the other community, it was more than clear that this system was an unbalanced one, favoring rather the Turkish minority. The unbalanced divisionist elements of the Constitution rendered the functioning of the government extremely difficult and the independence of the country very fragile. In addition, the two treaties, that of guarantee and that of alliance, facilitated those favoring the abolition of independence. It was then not of a surprise that less than 3 years after independence, intercommunal conflict spread all over the island and dominated the lives of the Cypriots. The state of Cyprus came to the verge of collapse. 10 years later, Turkey invaded the island and achieved the de facto partition of the island, aiming in fact at the Europe partition or even at the domination of the whole of the island through the negotiations for a solution which have been going on for more than 46 years, relying at the same time on the military advantages she gained by the invasion and occupation of 36% of the island's territory. To the above, we should add the right of the United Kingdom to preserve in Cyprus two sovereign bases in the south of the island, rendering in practice the state of Cyprus enclaved between the Turkish occupied area in the north and the British sovereign bases in the south. A marvelous sandwich, as I sometimes like to say, turning into a joke the tragic situation of our country. Then a number of inevitable questions arise. Why the armed struggle for enosis? What made impossible the avoidance of the divisionist elements of the Constitution? Could the UK play over the years a more constructive role as the former colonial power and in particular as the neutral guarantor power? Has it exercised its obligation to protect Cyprus' independence? What are the prospects for the survival of Cyprus as an independent state? I hope that some at least of these questions will find their answers in the presentations of our today's eminent speakers. Thank you.
Just 2 words and you can stay here. Thank you, Mr. Arestis, for this introduction and welcome address. If you don't mind leaving with us the questions that you have asked, because they are very pertinent and very salient. So we'll try to make sure that we answer them. I know that you have to depart before we do. So if you leave them with me, then thank you. They were fundamental questions. Thank you very much. So now let me introduce our first speaker or next speaker, Dr. Chagos, who is an assistant professor at the School of Law of Euclid Cyprus, and he's also the deputy head of the school, my colleague. Thank you, Clarke, for being here. And he's also, of course, behind the organization of this symposium. Chagos is going to talk to us about the cracked colonial foundations of a neo-colonial constitution, very ambitious. Chagos, the floor is yours. Thank you very much.
Thank you very much for that warm introduction.
Wait a second for the microphone.
Thank you very much for that warm introduction. I want to begin by saying how honoured I am to be in the presence of such distinguished company. Two gentlemen who played a critical role in support of the rule of law amid the systemic injustices that we see all around us. So it's a great pleasure to be here with you both this evening. My presentation today is entitled The Cracked Colonial Foundations of a Neo-Colonial Constitution. For that reason, my presentation has one aim. It is to advance a thesis which flows from a formidable body of evidence. The thesis relates to the Constitution of the Republic of Cyprus, which I will, from here on in, refer to as the 1960 Constitution. That Constitution came into force in the English language, I stress that, at midnight on the 16th of August 1960. My thesis is this: at the moment when it came into force, the 1960 Constitution stood on British colonial foundations, which were cracked and thus defective. In turn, those British colonial foundations rested on an underlying Ottoman Turkish colonial bedrock, which was likewise cracked and thus defective. Those cracks existed because of the but unmistakable organizing principle which was common to the Ottoman Turkish colonial epoch in the island of Cyprus from 1571 until 1878, the British colonial epoch from 1878 until 1960, and the new epoch heralded by the 1960 Constitution. That unspoken, mistaken organizing principle was segregation. Let me not beat about the bush. Segregation was exploited by Turkey and the United Kingdom to overcome the demographic realities which were inconvenient to both Turkey and the United Kingdom, both of which wanted to prevent any application of either democracy or self-determination. Under the official population census carried out by the British themselves in 1946, in the then British Crown colony of Cyprus, 78.2% of the population identified itself as Greek Orthodox, 17.5% identified itself as Muslim Turkish, and the remaining 4.3% identified as adherents of other religions. These were the labels that were fashionable back then in the British Crown colony of Cyprus, and they appear embedded in the census of that year, 1946. The adherents of those other religions appear to have included Armenian Orthodox Christians, Maronite Catholic Christians, and Latin Catholics. Now, with that introduction in mind, let me ask the obvious question: what is segregation? It's a word that we don't often hear in the lexicon of the Republic of Cyprus. We certainly don't hear it spilling the lips of the diplomats who are parachuted into the Republic of Cyprus from time to time in order to promote segregation. The obvious answer to what is meant by segregation is that it is the undemocratic antithesis of integration. Integration is a concept associated with pluralist liberal democracy. It's an irony, but integration and pluralism go hand in hand. Segregation, and what we've come to know here in the Republic of Cyprus as bicommunalism, likewise go hand in hand, contrary to fundamental principles of democracy, such as the ones I've just mentioned. For an authoritative dictionary definition, one may turn to the Oxford English Dictionary, published by Oxford University Press. This defines segregation as the action of segregating, and more specifically, as the separation or isolation of a portion of a community or a body of persons from the rest. The Oxford English Dictionary goes on to provide a number of alternative definitions, which amounts to the same thing. One definition equates segregation with the dispersion or breakup of a collective unity. Another definition equates segregation with the enforced separation of different racial groups in a country, community, or institution. And hence, the Oxford English Dictionary reminds us, segregation may be compared with apartheid, an Afrikaans word which means separateness, although it's sometimes interpreted as aparthood or apartness. What is wrong with segregation? I turn to the immortal words of the late Dr. Martin Luther King Jr. In his assessment, segregation is evil. As Dr. King argued in an address entitled Desegregation in the Future, which he delivered in New York on the 15th of December 1956, segregation has always been evil, and only the misguided reactionary clothed in the thin garments of irrational emotionalism will seek to defend it. Segregation is both rationally inexplicable and morally unjustifiable. So Dr. King equates segregation with both irrationality and immorality, hence his use of the word evil. Dr. King, and he was speaking here on the 15th of December 1956, 4 days before a criticism in the history of Cyprus, which I'll come to in a moment or two. On the 15th of December 1956, Dr. King advanced at least 3 basic reasons why segregation is evil. One reason is because segregation inevitably makes for inequality. Inequality, the antithesis of the democratic principle of equality before the law, by which we mean the equality of the individual before the law, not the equality of a community before the law, but the equality of the individual before the law. A second reason why segregation is evil is because segregation scars the soul of both the segregated and the segregator. The third reason why segregation is evil is because it ends up depersonalizing the segregated person, so that such a person becomes merely a thing to be used, not a person to be respected. And we have in this room people who have been shoved around because of their background. They prove the point that a person becomes used or shoved around in the interests of segregation. Now, on the 19th of December 1956, 4 days after Dr. King issued these remarks, the British Colonial Secretary of the day, Alan Lennox Boyd, appeared in the House of Commons, ostensibly to present the Radcliffe Plan, which was cooked up by Lord Radcliffe, a law lord. He'd been involved in the partition of India in 1947, and then he ended up in Cyprus preparing a constitution. But Alan Lennox Boyd, the Colonial Secretary, used this opportunity 4 days after Dr. King issued those remarks to prepare the ground for a mixture of what's come to be known as bicommunal segregation and bizonal segregation. This is what Alan Lennox Boyd said on the 19th of December 1956. Her Majesty's government recognised that the exercise of self-determination in such a mixed population must include partition among the eventual options. This reflected secret Anglo-Turkish scheming behind the scenes with the aim of engineering a partition of the island of Cyprus. The British Prime Minister of the day, Anthony Eden, who's gone down in infamy over the the UK-French invasion of Egypt, approved of partition, provided there was a partition into 3, with British, Turkish, and Greek zones. And the word zones was used in the secret scheming in late 1956 in London, in Turkey, in Ankara. Now, let me come back to the point of segregation and the prelude to the Constitution. In both the United States of America and the island of Cyprus, segregation was an outgrowth of both colonialism and slavery. That being said, a key difference between the 2 cases, the United States on the one hand, Cyprus on the other, lay in the Ottoman origins of the peculiar form of segregation effected in the island of Cyprus. There, or should I say here, an inherently by-faith form of segregation became entrenched, initially during the slave-ridden Ottoman epoch after 1571, and thereafter during the post-slavery British epoch after 1878. The evidence of systemic, what I would call systemic by-faith segregation, lies in British colonial laws applicable in Cyprus during the British epoch. These include the British colonial laws, which refer to non-Mohammedan voters and Mohammedan voters, as per the proclamation issued by the then British High Commissioner on the 15th of February 1883. These also include the references to non-Mohammedan persons duly qualified as electors and Mohammedan persons duly qualified as electors, as per the British Ordering Council made on the 6th of February 1925. And this form of by-faith segregation is also reflected in the references to Christian electors on the one hand and Muslim electors on the other, as per the British Municipal Corporations Amendment Law of the 27th of October 1948. These, I stress, were British colonial laws enacted here in Nicosia or in Buckingham Palace but applied to the people whom the British, in line with what the Turks had done previously, had segregated into two communities consisting of Muslims on the one hand and non-Muslims of the other. In other words, what the British did was they were fulfilling a basic tenet of Islamic or Sharia law, the separation of human beings according to whether they were adherents of Islam or non-adherents of Islam. And the British made no bones about it. They used this form of terminology during the British colonial epoch. What made this even more preposterous from the standpoint of democracy was that the segregation into Muslims and non-Muslims was supplemented by the supremacism of male Muslim men over female Muslim women. This came across, believe it or not, in 1951. In January 1951, on the 29th of January 1951, when we had a Labour government in London that's gone down in history as one of the most progressive governments of all time. It introduced the National Health Service, for example. And yet here, in the island of Cyprus, that Labour government introduced what was called the Turkish Family Marriage and Divorce Law of the 29th of January 1951. This was applied to what the law described as the Turkish Muslim community of Cyprus, Muslim spelt M-O-S-L-E-M. Despite the ethnic Turkish label applied to the Turkish Family Marriage and Divorce Law of 1951, its substantive effect was to perpetuate what I've just mentioned, one of the core principles of Islamic law, which was, of course, a principle of Ottoman law. It also perpetuated parallel systems of family and matrimonial justice, which the British had inherited from the Ottoman Turks in 1878. What the British did was they changed the label from the Muslim Religious Tribunal, which was the phrase that was used in 1878, to the Turkish Family Court, which was the phrase used in this law. And look what we find in section 7.1c of this Turkish Family Marriage and Divorce Law of 1951, which is a British colonial law. A marriage is prohibited between a Muslim woman and a non-Muslim man. In other words, there was a prohibition on intermarriage built into this law. And also, there was discrimination built into this law because there was no equivalent prohibition against a Muslim man marrying a non-Muslim woman. Now, during the point I'm making here is, this is Martin Luther King's point. Where you have segregation, you inevitably have inequality following from it. And the British experience in Cyprus proves, I would suggest, Martin Luther King's argument in a different context to the one that Martin Luther King emerged from in the United States. Now, during the 1950s, the British authorities engaged in an Orwellian process of name changing. They stopped using the religious labels, at least in public. They did refer to the religious labels in some of their colonial laws and some of their official statements in the Gazette, the government newspaper that was published from time to time. But in public, at least, what they started to do was to relabel Christians as Greek Cypriots and to relabel Muslims as Turkish. And this relabeling exercise took place in phases. Initially, in 1954, Henry Hopkinson, the then Minister of State, referred to the Greek Cypriot part of the population and the Greek-speaking part of the population and the Turkish-speaking part of the population. The phrases Greek Cypriot and Turkish Cypriot came to prominence with Lennox Boyd in 1956. The phrases pre-existed in 1956, but they came to prominence with the Lennox Boyd statement I've just referred to, where he let the partition cat out of the bag. We now turn to the Constitution. It was a product of a political and diplomatic fix. It was not the outcome of any expression of free will by the people of Cyprus, nor was it the product of any democratic process involving transparent consultation exercises or democratic and transparent referendums. It was the product of a diplomatic and political fix, initially in Zurich on the 11th of February 1959, involving the Greek and Turkish governments. Then over dinner in London, when the Greek and Turkish representatives came over to deliver their deal to the British approved a secret deal in Zurich, and we ended up with two gentlemen purportedly acting as the representatives of the Greek Cypriot community and the Turkish Cypriot community, entering into what became known as the London Agreement, which cemented segregation and paved the way towards the Constitution. I'm approaching the end, and I'll just say about the Constitution itself before I close. I'll begin with the opening words. We don't see any majestic, inspiring words of the type we find in the United States Constitution that refers to justice and happiness. We find the following words in Article 1 of the Constitution, which I stress was cooked up in secret, was not the subject of any democratic process. The state of Cyprus is an independent and sovereign republic with a presidential regime, the president being Greek and the vice president being Turk, elected by the Greek and Turkish communities of Cyprus, respectively, as hereinafter in this Constitution provided. In Article 1 of the Constitution is yet further proof or evidence in support of Dr. King's point. Segregation requires inequality. The Constitution provided for a Greek president. In other words, non-Greeks were barred from becoming elected as president. So any citizen of the Republic of Cyprus who did not fall into the definition of a Greek was subject to systematic, constitutionally sanctioned, and legally enforceable segregation and discrimination, with the inequality that flows from that. In parallel, because it referred to the two communities which were given this peculiar status under the Constitution, there was no meaningful application of self-determination, democracy, or meritocracy. The culture of corruption that appears to exist in parts of the Republic of Cyprus, where people are promoted, or some people are promoted on the basis of who they know rather than what they know, I would suggest owes at least part of its origins to the Constitution that created a culture of non-meritocracy. You reached the top of the presidency because you were Greek. If you didn't fall within that definition, you were barred from reaching the top. There were peculiar provisions built into the Constitution. The civil service was arranged on a 70%, 30% basis. So people were not appointed to the civil service because they deserved to be promoted. They were promoted because they were able to tick a box that fell within one of the two communities, as described in the Constitution. Now, I've been searching for comparable constitutional systems around the world, and I didn't have to go very far. These are pretty dismal precedents. One is Lebanon, next door to us, which has become a byword for corruption and for dysfunctional governance. It has a constitutional system under which the president must be Christian and the prime minister must be Muslim. If we go even closer to us, to Syria, under Article 3 of the Constitution, the religion of the president is Islam. So what we find in the Eastern Mediterranean are three case studies of constitutional systems which, at their very essence, are built on segregation, discrimination, and inequality. I now turn to Article 2 of the Constitution. I'm not going to refer to many, and this is going to be perhaps where I'm going to begin to draw to a close. Article 2 defines what is meant by the so-called two communities. The phrases themselves are misleading for reasons I'll explain. The Greek community is defined with reference to, inter alia, members of the Greek Orthodox Church. Article 2.2 is defined with reference to, inter alia, Muslims. In other words, the 1960 Constitution takes us back to the Ottoman epoch and the division between Muslims and non-Muslims. And I say that because Article 2.3 effectively required anybody who was Armenian, Maronite or Latin to belong to the Greek community. And indeed, the Maronites, Latins and Armenians were relegated to a subordinate status collectively as members of religious groups. So they were themselves subjected to the inequality that Martin Luther King warned us about. Where you have segregation, you have inequality. In keeping with this organizing principle of segregation, the 1960 Constitution constitutionally authorized one structure of segregation after another. Among the structures of segregation authorized, foreseen, or referred to by the 1960 Constitution were the two communities themselves, a phrase found in Article 6, 123, 125, and a number of other articles. Two separate Greek and Turkish primary school systems. The British had previously had a Christian school system and a Muslim school system. Here we have the Constitution authorizing separate primary school systems. We have two separate communal chambers. They fell away after the troubles of 63-64, but they were embodied in the Constitution as living embodiments of segregation. We even have two separate Greek and Turkish electoral lists under Article 63. That takes us back to the British colonial lists with Muslim voters and non-Muslim voters occupying separate electoral lists. We even have the process of separate municipalities, councils in other words, to be created in the 5 largest towns, that is to say Nicosia, Limassol, Famagusta, Larnaca and Paphos, by the Turkish inhabitants. So the councils were going to be arranged on a segregated basis as well. This was, I would suggest, a forerunner to the geographical segregation enforced by Turkey, initially after the 63-64 troubles and later with the 2 Turkish invasions of 1974. All this helps to explain and account for the theme of division as identified in a judgment handed down by Mr. Justice Vassiliadis in 1961 in the then High Court of the Republic of Cyprus in the case of Chagos and the police. Mr. Justice Vassiliadis pointed to the division of citizens into Greek and Turkish. The judge then explained that this was a division permeating the whole of the Constitution of the Republic of Cyprus. Mr. Justice Vassiliadis, who later served as President of the Supreme Court of the Republic of Cyprus, added, the very first article in the Constitution speaks of the 2 separate communities, and Article 2 defines the division and places the citizens into either one or the other of the 2 distinct communities. With very few exceptions, this division runs from the top down to the roots of the structure of the state. And within 3 or 4 years, the state effectively collapsed, and it was rescued by the Supreme Court decision that activated the doctrine of necessity. But the fact that the Constitution was built on segregationist foundations proves, I suggest, my point that the foundations were cracked, and it's never wise to build any structure on cracked foundations. I'm going to close with a couple of thoughts. Within a few years of 1960, segregation was unequivocally condemned by a succession of international conventions. One example is the 1965 International Convention on the Elimination of All Forms of Racial Discrimination. This was adopted just a few months after Martin Luther King received the Nobel Peace Prize in December 1964. The preamble of the 1965 Convention affirms that the United Nations has condemned colonialism and all practices of segregation and discrimination associated therewith. So the Convention, which is dedicated to countering discrimination, recognizes that colonialism, segregation, and discrimination go hand in hand. Meanwhile, under Article 3, states parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit, and eradicate all practices of this nature in territories under their jurisdiction. A second example is the 1973 International Convention on the Suppression and Punishment of the Crime of Apartheid. Its preamble affirms that an end must be put to colonialism and all practices of segregation and discrimination associated therewith. The 109 state parties to the Crime of Apartheid Convention do not include the Republic of Cyprus. The 109 state parties do not include any of its 3 so-called guaranteeing powers, Greece, Turkey, and the United Kingdom. One wonders why. In 2017, I tried to find out why by writing to the governments of the Republic of Cyprus, Greece, and the United Kingdom. but none of them chose to answer. So perhaps in response to this symposium, they might want to do so. I close with the following thought. Today, 60 years after 1960, the Republic of Cyprus remains mired by an even more enhanced and even more reprehensible form of segregation than the constitutional form of segregation effected in 1960. I refer, of course, to the enforced physical segregation of citizens of the same sovereign state. This enforced physical segregation came about as a result of the two Turkish invasions of 1974 and the failure of the United Kingdom to do anything about it as a guarantor power or as a permanent member of the Security Council. And the issuing of paper resolutions in the Security Council, which are not backed up by Chapter 7 enforcement mechanisms, doesn't count as taking effective action. How did this enforced de facto bizonal segregation come about? It came about through forcible transfers, acts of ethnic cleansing, and inhumane acts contrary to international human rights law, and it would appear contrary to international humanitarian law. I've had to put that qualification in because there's been no international criminal court established to deal with the self-evident violations of international humanitarian law in the Republic of Cyprus. What has been the response of the United Nations to these bicommunal and bizonal forms of segregation? The response of the United Nations is to call for even more segregation, to legalize these forms of segregation through the proposed bicommunal and bizonal federation. 60 years on from the establishment of the Republic of Cyprus, the time has surely come to consign both segregation and the occupation of the north of the Republic of Cyprus to where they belong, the dustbin of history. I close on that thought, and thank you for listening. Thank you.
Thank you so much, Clearche, for clear, deep, and no doubt provocative thoughts. I have, kept some highlights and quotes, particularly, the product of a political and diplomatic fix cooked up in secret. That's something we'll probably come back to the discussion table. And so many other facts, historical facts that you have used to build the argumentation, which I think is very important for the participants. And the concluding remark is obviously quite strong and even disturbing, but here we are. We have to be realist. Okay, I see that some people have some comments in the chat, but it's just, to thank you and encourage you. So we will take questions at the end. There is a Q&A session at 7:15. If we keep it that way, we will probably even get the Q&A session before 7:15. So that's good. Let me introduce you now to our colleague, Nasia, who is online. So Nasia, you can now show your face if you want to. Dr. Athanasia, or Nasia, as we know her, Haji Georgiou, assistant professor at the School of Law of UK and Cyprus, LLB course leader at the School of Law. Nasia is an expert in public international law, and she has worked extensively on the sovereign-based areas, including with the legal services of the Republic of Cyprus. So Nasia is going to talk to us about the sovereign-based areas, SBAs as we know them, and the principle of self-determination, trying to draw some critical assessment. Good luck to you, Nasia. Are you here?
I am here. Hi.
Very good. Thank you for sharing the handout in the chat. That brings me to actually the point that is in the next comment. All papers will be collected from the speakers, will be placed onto the Microsoft Teams folder, which you are all added to, so that you can actually look at them in your own time. And also the whole symposium will be added to the YouTube channel of the university so that you can actually share the symposium, view it and share it as you wish. Nasia, the floor is yours. Thank you.
Thank you very much. I can hear an echo though.
Yes, I'm going to switch off our microphone now.
Okay, great, thanks. Okay, so hi everyone. Before I start, let me just make two preliminary points. The first is that because Stephanie mentioned my collaboration with the legal services, I would like to make it clear that whatever I say is a personal opinion and all the sources that I have used are publicly available. The second thing is that because I will be referring to several legal authorities and I will be quoting extensively, I have included the authorities and the quotes in the handout that I uploaded on the chat right now, so you can all follow. So, starting with the substance of the presentation. The objective of today's presentation is to try and explain what the SBAs are, and then assess whether their existence is compatible with international law, and in particular with the principle of self-determination. So starting with a description of what they look like. Practically speaking, they are two relatively large pieces of land called Akrotiri and Ageia that combined make up about 3% of the territory of the island of Cyprus. They are inhabited by about 3,500 soldiers and civilian employees of the UK government and another 4,000 British family members, together with about 10,000 locals. So combined, the population of the SBAs is just shy of 20,000 people. There are two, as I said, SBAs in Cyprus, and both are parts of the British Overseas Territories. However, unlike the other British Overseas Territories that fall under the responsibility of the Foreign and Commonwealth Office, the SBAs are, for reasons that will become clear, the responsibility of the Ministry of Defence of the UK. Legally speaking, the SBAs are the twin of the Republic of Cyprus, as they were both created by the Treaty of Establishment, which was signed by the UK, Greece, Turkey, and Cyprus. Now, even though we know what the SBAs look like, their legal status is a bit more cloudy. So if we start from the Treaty of Establishment, which I think makes sense that we do, Article 1 states that, and this is a quote from the handout, the territory of the Republic of Cyprus shall comprise of the island of Cyprus, together with the islands lying off its coast, with the exception of the two areas, which areas shall, and this is the important bit, shall remain under the sovereignty of the United Kingdom. The key here is remain, which suggests a continuation between what existed before 1960 and what exists now, namely a continuation between the colony of Cyprus and the SBAs. This is confirmed by the Cyprus Act 1960, which is, I should highlight, a British statute, stating that the Republic of Cyprus will comprise of the island of Cyprus with the exception of the two areas, and it goes on to provide that, again a quote, nothing in the foregoing section shall affect Her Majesty's sovereignty or jurisdiction of those two areas. So what this document seems to be implying is that the Queen, the monarch, has sovereignty and jurisdiction over these areas, and it will not be affected by the Cyprus Act. The position that the SBAs are a continuation of the British colony of Cyprus was repeated a couple of times by SBA court cases. For example, in Antoniadis and Aziz, the full citation of the two cases are in the handout. But it was most authoritatively confirmed in Bashir. a UK Supreme Court decision which unanimously decided in 2018 the following. The Cyprus Act, again I'm quoting, the Cyprus Act 1960 did not alter the status of the SBAs, but merely excluded them from the transfer of territory to the new Republic of Cyprus. In the case of the SBAs, the only change which occurred in 1960 was that whereas they had previously been part of the UK dependent territory of Cyprus, they were thereafter the whole of it. So what this is saying in plain English is that what happened in 1960 might have changed the status of Cyprus as a whole, with the exception of the SBAs, which remained very much the same, what they had been until then. So for the British, the situation is clear. The SBAs are a colony. This is in contrast to the Cypriot position, which I have to say I find less convincing. The starting point for the Cypriot Supreme Court is Article 1.2 of Appendix O of the Treaty of Establishment, in which the UK declared, again not a quote, a quote, its intention not to set up and administer colonies on the island. Appendix O is an exchange of letters between the UK government on the one hand and Archbishop Makarios and Dr. Kuchuk on the other. It is unclear whether it is a legally binding document as such, but over the years, it has been treated as legally binding as a matter of practice by both the Republic of Cyprus and the UK. So building on this declaration of intention not to develop colonies, the Cypriot Supreme Court decided in a case called Estia in 1991 that, and again I'm quoting, there is no doubt that the sovereign base areas are neither a state nor a colony, but areas of the island of Cyprus over which the United Kingdom, during the establishment of the Republic and for military and defense purposes only, retained its sovereignty subject to the restrictions referred to in the above multilateral and bilateral documents. The above multilateral and bilateral documents are the Treaty of Establishment and Appendix O. So what is this telling us is that the SBAs are definitely not a colony. They are something unique, a sui generis structure that the UK has sovereign rights to, but only for specific military purposes. The problem with this position of the Cypriot Supreme Court is that it is not well supported by practice. There are, for example, several cases of Cypriot courts which assume that the UK has sovereign powers in the SBAs that are more expansive than just those relating to military matters. Most damaging to the Cypriot position, however, is not the case law, but the non-military development agreement that was signed between the Republic of Cyprus and the United Kingdom in 2014. In the handout, I have a link to the agreement. There are several provisions in the agreement that are eye-catching, but for our purposes, we don't need to look beyond Section 1. This allows, for the first time since 1960, for the defining of planning zones in the SBA. It basically gives the right to local Cypriots who have been living in the SBA and have been owning property in the SBAs to develop these properties. Crucially, the non-military development agreement states that the whole process of designing planning zones can be completed only, quote, subject to the consent of the SBA administration. The Republic can request the inclusion of planning zones, quote, in exceptional cases of public interest, and the UK, last quote, will give sympathetic consideration to these requests. So, to put it simply, the UK can decide, it has a final say, who gets to build what and where in the SBAs. However, if the UK has a say in the design of planning zones, its sovereign rights have to extend far beyond matters that are just relating to military and defense purposes. Now, I would like to pause here and tell you the story of another British colony, that of Mauritius. Mauritius is a complex of islands, and before its independence in 1968, these islands also consisted of Chagos Archipelago. 3 years before independence in 1965, the British separated Chagos from the rest of Mauritius and merging it with part of another colony, the colony of Seychelles, created a new colony, the British Indian Ocean Territory, or Biot. When the UK granted independence to Mauritius in 1968, Biot was not part of the deal. So Biot remained a colony while Mauritius received its independence. To this day, Biot remains a British colony, which is used as an American military base. In 2019, the International Court of Justice delivered its advisory opinion on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. In an uncharacteristically bold advisory opinion, I don't think I've ever read anything like this from the court, the ICJ unambiguously stated that the right to self-determination, and again I'm quoting, is defined by reference to the entirety of a non-self-governing territory. States have consistently emphasized, continues the court, that respect for the territorial integrity of a non-self-governing territory is a key element for the exercise of the right to self-determination under international law. And it then goes on to say, it follows that any detachment by the administering power of part of the non-self-governing territory, unless based on the freely expressed and genuine will of the people of the territory concerned, is contrary to the right to self-determination. In simple English, you cannot split up a colony and give only to part of that colony its independence. It has to be the whole, unless the people have expressly agreed to this separation. The court concluded that the separation of the Chagos Archipelago from Mauritius constituted a wrongful act of continuous character, meaning that the UK remains today under a legal obligation to stop its administration of Biot so that the decolonization of Mauritius can be completed. Now, drawing parallels, and I am oversimplifying here, I will qualify that in a minute, one can imagine, it's not unreasonable to assume, that the UK is under a similar obligation to stop its administration of the SBAs so that Cyprus's decolonization can be completed. So the similarities between Chagos and the SBAs are uncanny, and at first glance, it could even be argued that Cyprus has a stronger case than Mauritius. This is mainly because of two factors. One has to do with geography. Mauritius is about 2,000 kilometers away from Chagos, while the Gege and Akrotiri are on the island of Cyprus. The other has to do with history. And it has to do with the fact that Chagos was divided from Mauritius 3 years prior to Mauritius's independence, while in Cyprus, the separation of the SBAs and the establishment of the Republic happened at the same time and in the same document. The fact that the Republic's independence was conditional on the British retaining the SBAs has been confirmed by classified cabinet papers. As early as 1957, in a document entitled Note by the Prime Minister, we read the following. It must be understood, however, that they, and by they we mean the Majesty's government, this is a note written by the Prime Minister at the time, it must be understood that the Majesty's government would not regard any solution as acceptable which did not allow them to retain their minimum essential military facilities under British sovereignty. So basically the Prime Minister told us, yes, Cyprus can get its independence as long as we're being clear, we are safeguarding our military interests and we're maintaining sovereign rights in doing so in the form of the SBA, which is precisely what happened. However, there is one major difference between Cyprus and Mauritius, and it is this that makes the argument that the British are violating Cyprus's right to self-determination difficult to sustain. Mauritius has been arguing since almost immediately after its independence that Chagos is part of its own territory. The Republic of Cyprus has done nothing of the sort. To the contrary, it has signed a series of agreements and memoranda of understanding with the UK about the SBA. And these agreements and memoranda of understanding unambiguously accept and confirm the SBA's legality. Among these are the non-military development agreement of 2014 that I mentioned before, but also protocol number 3 to the Treaty of Accession to the European Union, and most recently, as part of the Brexit process, the protocol to the withdrawal agreement. As recently as June 2020, 5 months ago, the British and the Cypriot governments issued a joint statement about the continuing successful implementation of the non-military development agreement. So even if Cyprus did not consent to the existence of the SBAs before independence, it has arguably consented on numerous occasions since. Now, had the principle of self-determination been classified by the court as a jus cogens norm, a peremptory norm, this would have strengthened the argument that the establishment of the SBAs is in violation of international law. This is because Articles 53 and 64 of the Vienna Convention on the Law of Treaties 1969 make it clear that if a treaty is in violation of a jus cogens norm, it becomes void and terminates. So even though Cyprus has signed a number of treaties confirming the SBA's legality, had the right to self-determination been a jus cogens norm, these treaties would have to be set aside. The International Law Commission, which is authoritative, has accepted that the principle of self-determination could be considered a jus cogens norm. However, even though several states, including Cyprus, referred in their submissions in the Chagos advisory opinion to jus cogens, the ICJ did not comment on the argument at all. So in conclusion, the law relating to the right to self-determination is difficult to enforce. The UK has not complied with the ICJ advisory opinion, stating that it is not legally binding. And I don't imagine that the UK will be complying with the ICJ advisory opinion anytime soon. Even though it's difficult to enforce, the law is nevertheless clear. Separating part of a colony and keeping it under colonial rule is illegal. What is less clear, however, and what clouds the discussion, is the status of the SBAs themselves. Rather paradoxically, if we accept the British position, which was cemented, crystallized in Bashir, a case decided a year before the ICJ advisory opinion, so if we accept the British position that the SBAs are a colony, then their very existence is definitely in violation of international law. If we accept the Cypriot position, however, and as I said, there are problems with accepting the Cypriot position, namely, if we accept the fact that the SBAs are a unique sui generis entity, then the legality of these structures, of these entities, becomes even more uncertain. And I will leave you with that. Thank you very much.
Thank you, Nasia. Thank you so much for this very difficult exercise that you have actually entered into, describing to, well, a large audience with different levels of public international law, very complex concepts and cases. So thank you for this. It's really appreciated. Of course, I cannot resist, but well, asking, but we can keep this for the end. To develop the dimension, today's dimension, including, of course, the status of the SBAs under EU law, because you know that this is one of my favorite subjects, but also post-Brexit. So yes, definitely there is a lot to say here. Now, we are ahead of schedule. This is wonderful. It's a unique situation. Thank you, Nasia. You can switch off your camera if you want to. So we move on to our next speaker. Obviously, we have introduced him already, Kostas Clearidis. We are very happy to have you with us, and we are even happier to listen to you. So, Mr. Clearidis, of course, will be discussing, well, the status or the organ of the Republic that he probably knows best following his retirement. And we will basically concentrate on the constitutional status of the Attorney General of the Republic of Cyprus as enshrined in 1960. So, Mr. Clearidis, the floor is yours. Thank you very much.
Thank you. Dear organizers of the symposium, dear Stephanie, dear Claire, distinguished speakers, George, Claire, and Nasia, and dear participants. Let me first say that I reserve my right to express my gratitude to UCLAN for the granting or for the award of the doctorate, since the ceremony, I understand, has been postponed because of the pandemic. So I reserve my right to express my gratitude during the ceremony. I would like to congratulate at first the organizers for this interesting symposium and for their initiative to contribute towards the celebrations for the 60th anniversary of the establishment of the Republic of Cyprus through this highly interesting event. I must say that UCLAN Cyprus, and especially the School of Law, have always been very active in promoting scientific research and knowledge on numerous legal, political, and social issues of general importance and interest, which at the same time present a special interest to the hosting country, Cyprus. I have been kindly invited by the organizers to give a short speech under the title, The Constitutional Status of the Attorney General as Enshrined in 1960. And having left this honorable post only 5 months ago, I readily accepted the invitation. In this short contribution, I can only give a general description of the main features, duties, functions, powers, and privileges granted by provisions of the Constitution to the Attorney General, and at the same time I will express some personal thoughts and ideas arising out of my own experience as the holder of this important post for a period of almost 7 years. Following the agreements for the termination of the colonial status of Cyprus and the granting of independence, the need for a written constitution, explicit in its terms and strict in its application, immediately arose. Thus, the Constitution of the Republic of Cyprus was drafted in such a way as it was justifiably characterized by jurists as one of the most detailed and rigid constitutions in the world. Amongst other special characteristics, this constitution contained divisive provisions, as Mr. Clerk was referred to earlier, as to the granting and the sharing of powers between the two main communities on the island, the Greek Cypriots and the Turkish Cypriots, the good relations amongst which had suffered severe blows during the last few years of the colonial rule. It must also be mentioned that the Constitution of 1960, which contained, inter alia, strict safeguards as to the enjoyment of fundamental rights and liberties of all citizens, and of course as to their limitations, was never put before them for approval or rejection through a referendum or other democratic method. Neither was it brought up for ratification at any stage. It was only signed by the leaders of the communities acting on their behalf, as Claire Hoss has already mentioned. It must have not escaped the minds of the drafters of the Constitution that in view of its provisions, many of which were unique in the sense that no similar provisions were found in the constitutions of any other country, difficulties as to its applications were bound to arise sooner or later. It must have been obvious, if not taken for granted, that unavoidably novel and difficult legal, constitutional, and problems of international law were to arise at some stage regarding the proper application, the misapplication, or the non-application of many of its main provisions. In this respect, it is not perhaps surprising that quite extensive powers were given to the institution of the Attorney General of the newborn Republic as the highest ranking lawyer in the country and the organ responsible for advising as to the proper interpretation and application of the provisions of the Constitution, as well as for enforcing the law and order through criminal prosecutions. These powers were inserted in Part 6 of Chapter 1, Articles 112 to 114 of the Constitution, which provide for the institution of the Attorney General and the Deputy Attorney General of the Republic, both established as the highest independent officers in the state. The main functions and powers entrusted in the hands of the Attorney General are twofold. He is the legal advisor of the Republic and of the President of the Republic, of the Council of Ministers, and of the ministers. At the same time, the Attorney General is given extensive, if not absolute power, exercisable at his discretion and in the public interest, in order to institute, conduct, take over, and continue or discontinue any proceedings for an offense against any person in the Republic. This is Article 113. Leaving aside for the moment the absolute powers of the Attorney General in all criminal cases, the general powers assigned to him as the legal advisor of the Republic, coupled with the fact that he is granted security in office, thus serving not for the limited duration of the term of office of the President of the Republic who appoints him, but until the completion of the retirement age, makes the Attorney General one of the most powerful organs in the Republic. In order to give you an example of the important and numerous issues with which the Attorney General is entrusted by the Constitution to deal with, I can easily refer you to the topics chosen by the organizers as included in this symposium program, and as you have earlier on heard from the distinguished other two speakers. Having had the advantage of listening to the very able speeches of Dr. Kyriakidis and Dr. Nasia Hadjigeorgiou earlier on, I could refer you to the role played by the Attorney General in each one of the important issues involved in them. The first speech related to the inherently divisive colonial foundations upon which the Constitution of Cyprus was constructed, and the second related to the retention by the United Kingdom of two so-called sovereign base areas and the impact of this. Regarding the first issue, it is well known and has been very explicitly analyzed by Dr. Kyriakidis that the divisive provisions included in the Constitution and the complex checks and balances imposed, referred to by Mr. Arestis earlier on, with regard to the two main communities, were bound to create problems of workability and good cooperation. And indeed, they did create such problem as early as only 3 years following the implementation of the Constitution, when all of its fundamental provisions and structural arrangements regarding the sharing of powers and the checks and balances between the two communities became unenforceable as a result of the withdrawal of the Turkish Cypriots from all sections of government. Everyone can imagine the duty cast upon the shoulders of the legal advisor of the Republic, the Attorney General, to explore, propose, and implement legally and constitutionally recognized methods to prop up the state which was in effect falling apart. Resorting to the principles of the doctrine of necessity was the only available solution in order to avoid the complete collapse of the state institutions. The application of the doctrine was judicially accepted by the Court of Appeal in its judgment in the well-known case of the Attorney General of the Republic versus Mustafa Ibrahim and others in 1964. The President of the Appeal Court in his judgment made specific reference to the valuable assistance offered, especially on the legal background of the case, from the learned Attorney General who appeared as the appellant. Special reference was made to his able and most helpful address, in the course of which he had referred the court to reports of superior judicial authorities and to writings of eminent jurists showing how the doctrine of necessity had long been accepted and applied in other European jurisdictions. It is a well-known fact that the doctrine of necessity was resorted to and employed by other attorney generals in Cyprus until our days in order to support and save important pieces of legislation which had been enacted in contravention or not in conformity of express provisions of the Constitution and were otherwise bound to be declared as null and void. The role played by the Attorney Generals through the years which followed in succeeding to preserve the Republic of Cyprus as a worldwide recognized and legally constituted state was also of vital importance. The second issue on the agenda of the present symposium relates to the retention by the United Kingdom of two sovereign base areas and its impact upon the principle of self-determination. This theme has already been presented by Dr. Nasia Hadjigeorgiou in the most able manner, I must say. The role which the Attorney General has to play in the issues of the existence, the legal status, and the practical operation of the SBAs I must say, is both extremely important as well as continuous. During the first years of the Republic's life, the Attorney General had to deal with legal issues arising therefrom, both from an academic and theoretical point of view, as well as from a practical need to find solutions to problems arising out of the relevant treaty, the annexes, and its novel provisions, the appendices and all this. The most important legal issue, which still remains uncertain, relates to the question, what is the exact legal status of these bases? Opinions of the AG on these matters were repeatedly being sought and given, and the matter was also carefully presented before the courts in cases in which they were raised in one way or another. One important and always difficult to deal with aspect of this issue is the matter of the conflicting jurisdiction and other related matters arising in criminal cases, such as arrests of citizens of the Republic within the areas of the bases, issues of overlapping and optional jurisdiction, transfer of persons arrested, etc. Many of these issues keep the Attorney General and the officers of the law office quite busy, I must tell you. Another important issue on the matter of the SBAs is the agreement for the non-military development, the so-called NMD, referred to by Nasia, within certain areas of the bases, an agreement signed by the President of the Republic and the British Prime Minister a few years ago. The talks relating to the implementation of the provisions of that agreement present various problems which can justifiably be characterized as a lawyer's nightmare. The support of the Office of the Attorney General on many complex legal issues arising is sought and provided through a standing team of law officers which is in constant contact with the Ministry of Foreign Affairs under the supervision of the Attorney General. The specific issue of the impact of the continuous existence of the bases upon the principle of self-determination, analyzed by Nazi earlier, is closely related to the continuing dispute between Mauritius and the United Kingdom over the Chagos Archipelagos, which was dealt with by the United Nations International Court of Justice in The Hague in September 2018. The Republic of Cyprus took part in the hearing proceedings for an advisory opinion by the court, represented by a whole team of experts headed by the Attorney General, and the opinion, which was finally delivered by the court and referred to the General Assembly of the United Nations, is indeed an extremely useful tool in approaching legal matters arising out of the continuous existence of the bases in Cyprus. The examples given above serve to show that the Attorney General in this country has an important role to play in almost all serious issues arising in the Republic. Amongst these, we should include all novel legal matters arising out of the 2013 economic crisis, advising on legal and constitutional matters arising out of the COVID-19 pandemic, advising on matters of Cyprus's exclusive economic zone, especially in the context of international law and the law of the sea, advising and representing the Republic in matters of intellectual property, as for example in relation to the pending application for the registration of Halloumi as POP, and so many other important matters. Another important aspect of the duties of the Attorney General as the legal advisor of the Republic lies, of course, on the obligation to represent the Republic in all court cases, both in Cyprus and abroad. This includes thousands of civil law cases, administrative law recourses, disciplinary proceedings against civil servants, local and international arbitrations, and many other proceedings. In dealing with the aspects of the role of the Attorney General as the legal advisor of the Republic, special mention must be made to the duty cast upon him to ensure the strict and proper enforcement of the provisions of the European Convention for the Protection of Human Rights, most of which were adopted verbatim in the text of our Constitution. This role of the Attorney General spreads along the following obligations and duties. 1. The duty to act as the government agent, as a consequence of which all the recourses by private individuals complaining of violation of human rights are forwarded by the European Court of Human Rights in Strasbourg to the Office of the Attorney General, who collects the relevant facts from the relevant organs involved and decides as to the further handling of each case in the light of the Convention's provisions and the Court's case law. 2. The duty to take action or to advise for taking action in order to comply with judgments of the European Court of Human Rights or of the ECJ, which impose obligations upon the Republic. 3. The duty to give advice as to the compatibility of proposed legislative or other governmental measures with the provisions of the Convention and, of course, with the provisions of the Chapter of Fundamental Rights of the European Union and the relevant case law. 4. The duty to give advice as to the reviewing or amending legislation or administrative acts so as to be in conformity with the court judgments. Now, another feature of the role of the Attorney General as the top-ranking lawyer is the duty cast upon him to act as the honorary president of the Bar Council, as the president of the Legal Council, and as the president of the Disciplinary Board of the Bar Council. Reverting now back to the important issue of the criminal cases. The powers vested in the Attorney General are indeed strong and extensive, and in effect, they are beyond the control of the courts. The only criterion and the restriction imposed by Article 113 upon the AG in exercising his powers in criminal cases is the taking into consideration of the public interest. A decision of the AG, for example, to enter a so-called nolle prosequi, which puts an end to any criminal case, whether in public or in private prosecutions, has been held by the courts to be a decision beyond the control of the courts, as being an unfettered constitutional privilege. This very fact of enjoying an unfettered power, in my opinion, casts upon the Attorney General as an increased responsibility to exercise it with even greater caution and to be ready and able to give a proper and convincing reasoning which lies behind his decision in order to avoid or to refute any impressions of arbitrariness or other forms of abuse. Needless to mention here that the extensive powers of the Attorney General in all criminal cases cast upon him a special duty to actively assist in fighting the phenomenon of corruption in public life. In recent years, there has been an immense effort by law officers entrusted with presenting corruption cases and cases of the so-called white collar before the criminal courts. Despite the fact that many cases against persons holding high public office were successfully presented to the courts during the last few years, it is true that deficiencies and difficulties in this effort became apparent from the beginning due to the fact of the lack of knowledge and experience in the issues involved, such as in banking practices, accounting, economics, etc. Deficiencies and difficulties also arose due to the small number of available officers who were called upon to fight complex cases in the courts alone, without assistance, as against a team of able and experienced lawyers for the defense. The lack of specialized knowledge and experience in financial and banking realities was also apparent at the critical stage of the police investigations, which are of vital importance in the proper preparation of a case for the court. In my view, the setting up of a specialized department which will deal with economic crime, both within the police as well as within the prosecution office, along the lines, for example, of the British Serious Fraud Office, SFO, is a necessity in order to fight these kind of crimes effectively. Regarding the sentences passed upon persons convicted for criminal offences and without prejudice to the cardinal principles of the independence of the judiciary, special reference must be made to the fact that according to Article 53 of the Constitution, the prerogative granted to the President of the Republic to remit, suspend, or commute any sentence passed by a court in the Republic in all cases can only be exercised on the unanimous recommendation of the Attorney General and the Deputy Attorney General of the Republic. Again, in this respect, no limitations or criteria are imposed by the relevant constitutional provision. It goes without saying, however, that this prerogative must be exercised in the public interest and that valid and convincing reasons must exist and must readily be given where required. It should be noted at this point that this duality of powers vested in the Attorney General, comprising of his position as the legal advisor on the one hand and as the public prosecutor on the other hand, is not a common feature with other European states. Most of the member states of the European Union have a separate institution or office which is in charge of all criminal cases. The same also applies to England, the United Kingdom, whose common law legal system we otherwise follow in general terms. As it regards the necessary full independence with which the Attorney General must be vested, an objective observer will be able to diagnose certain apparent deficiencies which inevitably arise as a result of the duality of functions of the Attorney General. The functions of the public prosecutor do not present any problem, since in exercising his rights and privilege, the AG only represents the state, the Republic, and he acts in the public interest in any way he thinks fit. His independence in this respect, I think, is beyond any doubt. The exercise of the functions of legal advisor, however, may create, and in practice it does so, create problems of objective impartiality or apparent independence. According to the aforesaid Article 113 of the Constitution, the Attorney General is the legal advisor of the President and of the ministers. As a lawyer, he appears in person or through the officers of the law office in all cases, court cases, defending or representing the state, either as against claims of individual physical or legal persons or in favor of the interests of the state. In proceedings defending the acts, omissions, and decisions of the administration as against claims by individual citizens or corporations, the AG unavoidably has to take sides. However impartially he may appear to be acting, unavoidably he takes the side of the executive in defending or fighting a case, and in effect the relationship between counsel and client is created in these cases. A similar situation is created in all cases where the legal guidance of the Attorney General is sought by state officials who seek his opinion as to methods of promoting governmental policies or taking administrative measures. In all these cases, it can hardly be said that the AG acts as an independent and impartial officer. The distinction between the functions of the Attorney General is unfortunately playing its role in weakening the claim of the AG for more independence and autonomy. It should be noted at this point that the relevant observations and recommendations of European institutions, such as the Venice Commission and Greco, are mostly referring to public prosecutors when in their reports they insist on the enjoyment of the highest possible independence. This is a topic which is discussed these days because we had yesterday the issuing of the report of Greco, and actually there are remarks that the Office of the Prosecutors of the Attorney General have not yet gained the necessary independence. I must tell you that during my term, I had prepared a bill and sent it to the government through the Ministry of Justice, by which full independence and autonomy was to be given to the law officers of the Republic, of the Office of the Attorney General, in order for their appointments, their promotions, and secondments, and all this, not to be within the jurisdiction of the Civil Service, Public Service Commission, but under the jurisdiction of a body within the law office, comprising of the Attorney General, the Deputy law officers, and the judicial officers outside the law office, and possibly, why not, perhaps the President of the Bar Council or other representatives. Unfortunately, the bill was not pushed through. Having seen these deficiencies in practice during my term of office as Attorney General, I think it's time perhaps to discuss the idea of examining the possibility of dividing the constitutional functions of the Attorney General into two separate institutions to be headed by two different officers of the Republic. On the one hand, the law office or service of the Republic, headed by the Attorney General, and on the other hand, the office of the Public Prosecutor, or Prosecutor General, or Director of Public Prosecutions, or whatever he might be called. Such an officer, who will only be responsible for handling all criminal cases, will enjoy full autonomy without any objections from anybody. When I say autonomy, I include in this term the power to prepare a budget and to select, appoint, and promote all the law officers of his service through a selection committee. The law officers should no longer be regarded as civil servants, but they must be equated with judicial officers enjoying the same degree of independence and security of tenure. All matters relating to their service, promotion, secondments, discipline, etc., should be assigned to a committee, independent committee. This development will disengage them from the Public Service Commission and will undoubtedly contribute towards having a more reliable, efficient, and independent Office of Prosecutors. In concluding, I feel obliged to mention that personally I feel proud to have been in charge of the law office of the Republic for a term of almost 7 years. How important the role of the Attorney General is in a country like Cyprus is something which we all see in practice every day. In so many events and aspects of our political, social, and economic life. We have a duty to protect, to support, and to strengthen this institution for the sake of the smooth running of the law and order in our small country. Thank you very much.
May I quit? I have an obligation to go here.
Thank you, George.
Thank you for staying.
Thank you. I will take it for my privilege.
Thank you, Mr. Kiridis. Bye, George. Thank you, Mr. Kiridis, for sharing with us, some thoughts that are important for us because we look at them, from a different perspective, and your wise recommendations resonate in our ears. But not only the academics, I think the lawyers as well would agree with what you're saying. So we are happy and honored that we can basically benefit from your wisdom and your experience. There are many aspects that, of course, I'm sure will raise questions. So if you don't mind, we will turn to the Q&A session. So Nasia, you will have to come back also. What we are going to do is, if anyone would like to speak, you can either raise your hand on Microsoft Teams and we will give you the floor, or the micro rather, or write a comment or a question in the chat, in which case we will read it out. Now, for those of you who will decide to speak, provided the technology allows for this, please be brief and concise. I will ask Zora to go and stand there at the podium, and basically if someone wants to talk, we will have to mute ourselves, let the person talk, and then unmute ourselves. So the Q&A session is open. Who would like to go first? If someone wants to talk, I will tell you. Okay, so we have a question here, so I will read it out. So you no need to mute Zora for the moment because it's a question that I will read out. Two questions. The first one is from Achilleas. Can the panelists briefly comment on the role and responsibilities that can now be apportioned to or placed on the Greek/Greek Cypriot political leadership? Just a second. At the time of the negotiations of the London-Zurich agreements, which led to Cyprus' constitution independence. Okay, now, Klearchos, would you like me to read this again?
Yes, please.
Yes, so the question is, can the panelists briefly comment on the role or responsibilities that can be apportioned to or placed on the Greek/Greek Cypriot political leadership at the time of the negotiations of the London-Zurich agreements, which led to Cyprus' constitution and independence? That's a large question.
Shall I take it first? Or
You take it.
So you need to take the microphone and hold us a in your hand.
First of all, thank you for the question. It's an excellent one. It's a question that's preoccupied me for a number of years since I did my doctoral research in the 1990s. I could never work out what exactly was the precise legal basis upon which Archbishop Magarios and Dr. Kutchuk signed, or purported to sign, the London Agreement. The British had created these communities, which they kept on renaming as the years went by. I've given you some examples of the types of names that they were using. So it was never entirely clear to me what the legal basis of each of these two purported communities were at the time of the Zurich-London agreements. That's the first point. There's a question mark over whether or not these communities in law existed at the time of the London Agreement. The second issue is whether the two gentlemen who applied their signature, I'm referring to Archbishop Magarios and Dr. Kutchuk, were lawfully empowered to apply their signature, and indeed whether the purported offices that they held existed in law. The British in 1958 started to refer to these two gentlemen as the leaders of the two communities, a phrase which we still have today in the parlance of the United Nations. But I could never find out, and I'd be grateful if Achilles or anybody else can shed light on this, I could never find out what exactly was the legal basis of each of those two purported offices. And secondly, what the legal source of the powers purportedly wielded by each of those officers were. Because under English common law, for anybody to exercise power, they must be lawfully empowered to exercise power. And even if they have that power, they need to exercise the power within the four corners of the power that they've been given. I mean, that was a phrase that was used by Lord Green, the Master of the Rolls, in the famous case of Wednesbury in 1948, for example. So that's the procedural answer to the question. The substantive answer is that Archbishop Magarios, in my view, should have obtained independent legal advice from outside his closed circle of legal advisors, which, if I recall correctly, included, and I may be wrong here, Dasso Papadopoulos and Zenon Rosidis and a few other lawyers who were eminently able lawyers. But the question is, did Archbishop Magarios go outside the framework of the circle of Cypriot lawyers to take legal advice from the independent bar in England, or from firms of solicitors in England, or from specialists in international law? At the time, in the mid to late 1950s, the leaders of the Turkish community, as the British called it, took advice, if I remember correctly, from Professor Ivor Jennings, who was the professor of constitutional law at Cambridge. So the Turks were certainly going outside the local circle of lawyers to take legal advice. So yes, in the answer to the question, I suppose, is that a heavy responsibility must be placed on Archbishop Magarios as the purported representative of the Greek community, or rather it was called the Greek Cypriot community at the time of the London Agreement, then it changed its name to the Greek community by the time of the 1960 treaties, which Archbishop Magarios signed on the 16th of August. This is a matter for history, but in a sense, it's also a matter for present-day law and lawyers, because I hold to the view that there is a legal question mark over the whole 1959-60 arrangements. I mean, it's a controversial view. It can only ever be appropriately determined by an appropriate court of law. But there are legal question marks over what happened at London in particular, and there are certainly moral question marks. I think I'll leave it there, but that is a great question, and I could go on forever.
So, Mr. Klididis, and then Ignacia wants to add something. No? So,
yeah, just to add something to what Terhos has said. The argument put forward or the excuse given sometimes is that Archbishop Macarius was the undisputed leader of the Greek Cypriots, and also the only organ which was elected directly from the people, because according to the system followed by the Greek Orthodox autocephalous Church of Cyprus, the Archbishop is elected directly from the people. So they put forward this argument. But to my mind, it is inconceivable not to put these agreements or the Constitution in a referendum to be directly approved or rejected by the people, or at least to be later on ratified. I think in the case of Chagos, and this is another, Mauritius, I mean, this is another difference. It was later on ratified, the agreement for the cessation. In our case, not even that happened.
Nasia, would you like to add something?
Sorry,
No, okay, so stay where you are, Laura. Thank you. I will take the microphone and read the next question, and then we will pass to Sozos after I read the next question. So there is one more question in the chat from Andreas, who is a student of ours, and Andreas is asking, is the independence and the autonomy of the office of the Attorney General, well, you use the word decreased, okay, I suppose weakened by the appointment of persons previously holding political positions? If yes, how can the office of the Attorney General safeguard itself regarding the appointment of the AG itself? So I guess that goes to Mr. Cleridis.
thank you. Well, if you permit me, I will refrain from expressing an opinion or my view as to the current appointments. And I think it shouldn't be nice to do so for many reasons. What I can say is what I have publicly declared many times when I was asked either by journalists or by the President of the Republic, the same, that in my opinion, the post of the Attorney General should not be held by a person who is highly politically involved. I have said this repeatedly, and I have very good reasons for saying that. This is something which creates a lot of problems, not only for the institution, but for the holder of the institution, who will have to prove himself all the time that his decisions, his opinions, all his acts are not motivated by any political motivations. This is not good for the independence of the institution. This is the only thing I can say.
Thank you, Mr. Cleridis.
Yes. Yes, I will likewise refrain from commenting on the current holder of the office of Attorney General, but I will make two observations in relation to the office itself as it has been created in the Republic of Cyprus. The first point is in answer to the question that has been put, and there is a general principle that is applicable here. It's the common law principle articulated by Lord Hewitt, the then Lord Chief Justice, in the case of the Crown and Sussex Justices ex parte McCarthy. This was a case decided reported in 1924. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. So there is a duty on all persons involved in the system of justice, from the police officers who were involved in the original investigation through the prosecution decision-making that the Attorney General oversees, to the judges who are involved in determining the outcome of the matter if it's a criminal case, to ensure that justice is not only done, but it must be seen to be done. So what we in the common law give emphasis to are appearances. There may not be any bias on the part of a particular decision maker in this overall process, but there may be an appearance of bias, and we have tried and tested common law principles. The leading case on this involves Lord Hope in Porter and McGill. The lawyers can look up the test in their own time. My point is there needs to be an appearance of impartiality in addition to the reality of impartiality.
This is what is called objective impartiality as opposed to subjective.
Yes, thank you. The objective impartiality is what has been mentioned. The second point I would make is just a comparison with the Office of Attorney General as it exists in England and Wales. I've written at least a couple of articles on this. There are some areas of commonality between the Office of Attorney General in the Republic of Cyprus and in the United Kingdom. For example, both are legal advisors to their respective governments. Both are, in effect, involved in overseeing public prosecutions. Both hold important roles as guardians of the public interests. And both hold significant roles at the head of the bar. But there are at least two really fundamental differences between the Office of Attorney General in the Republic as against the holder of the Office of Attorney General in England and Wales. The first major difference is that in the Republic of Cyprus, the Attorney General is an independent officer under the Constitution who is clearly detached from both the Parliament, or the House of Representatives as it's called in the Republic of Cyprus, and the executive branch of government. They both have advisory functions in relation to the executive branch, but they are clearly detached from, the Cyprus one is clearly detached from the executive branch. In the United Kingdom, the Attorney General is both a member of Parliament, serving a constituency and sitting in the House of Commons, or from time to time in the House of Lords. But also, the Attorney General is a Minister of the Crown, and indeed is the superintending minister with responsibility for the Serious Fraud Office, Crown Prosecution Service, and one or two other departments. Now that causes problems with regard to the appearance of impartiality, because the holder of the Office of Attorney General in England and Wales is the holder of that office for as long as the Prime Minister chooses to keep him or her as Attorney General, whereas the Attorney General in the Republic of Cyprus has a greater security of tenure. So those are just some thoughts in answer to the question as to whether the British system, or the English system I should say, because the Attorney General is the Attorney General of England and Wales, as to whether the English and Welsh office holder has a better constitutional or more effective constitutional function than the Cypriot office holder is a matter for debate. But there are pros and cons associated with both holders of the office. For example, an advantage of the Attorney General being a Minister of the Crown and a Member of Parliament is that the Attorney General is accountable to Parliament and can exercise constitutional functions in support of Parliament, for example, through the provision of advice to Parliament. The Attorney General in the Republic doesn't have that parliamentary role, but on the other hand, the Cypriot Attorney General is not tainted by association with Parliament. So there are pros and cons to each variation of the Office of Attorney General.
Thank you, Jackie. Nasia, would you like to add something, or should I go to Sozos for his question? Okay, thank you. Thank you. So, Sozos, please, we will mute ourselves and you can ask your question. You need to mute ourselves, Zora. You know where? Yeah? No, the mic.
Okay, can you hear me? Please write in the chat because I cannot. Yes, okay. Thank you, Stephanie, for that. So first of all, I would like to really thank and congratulate all three speakers. First of all, well done, Claire. I know you have written extensively on the topic of segregation in the Cyprus constitution. It's a very interesting approach. I really wish that it's going to be taken sooner or later into consideration by our decision makers and politicians. That's all I wish at this point. So no question for you. Mr. Clearidis, thank you so much also for this very interesting presentation of the Attorney General's duties that are, of course, admirable. There are so many. I had the privilege to follow a similar presentation by yourself at the Rotary Club of Larnaca a few years ago, but I must say that the additions that you have brought to today's speech are really very, very important. I just have one small comment with regard to something it's dear to me, the halloumi protection and intellectual property. My remark here is that, unfortunately, unlike it was done in the Mauritius case, the AG office didn't take into consideration any opinions of local experts in intellectual property. I don't know why, maybe this is a question for you. Why are we using constantly foreign experts for such a subject, which is, of course, quite dear to our hearts? Now I'm moving to Nasia's speech, which will actually bring the core of my questions. Not so many. I have three, I think. I'll try to be brief, but I have to explain a little bit. They're not simple questions, obviously. First of all, just to agree with you, Nasia, on the advisory opinion on Chagos, Mauritius, with regards to the territorial integrity, the fact that the territory should not be split in a post-colonial era. This is the principle, of course, of uti possidetis juris that was largely applicable in Africa, but why not also in the rest of the world? On a second point, with regard to the 2014 agreement, I definitely agree that that was a very negative document, if I may say so, but it's not the only one, as you have mentioned. I just go back to 2003, the Memorandum of Understanding. That was the first, I think, should be the first real case where Cyprus agreed to something quite negative with regard to the basis. There were differing interpretations. There were some issues already with refugee asylum seekers because of the UK's reticence to recognize their status, etc. And then, of course, that was the worst document for me was Protocol 3, the accession to the EU, the fact that the bases had remained with our consent out of the EU, out of the acquis communautaire, and then by contrast, just to look at how easy it was for the UK at the time of the Brexit, when, unlike Spain with Gibraltar, we had immediately agreed to a very easy solution for the UK, so that the bases again remained outside of any control. Then the point on jus cogens. It's not Article 53 only of the Vienna Convention, of course. You mentioned it, I think it's 64 as well, is jus cogens superveniens, which is a peremptory norm that comes up later on. Here I just remind the audience as well of resolutions 1514 of 1960 and 2625 of 1970 of the General Assembly, which reaffirm the principle of self-determination even after the decolonization period, which is quite important for us and could be used. Last but not least, I'm sorry to be a bit long, on the legal status of the bases, I slightly disagree with your presentation, Nasia. Your presentation was indeed impressive, and I very much liked it. I would say that the Cypriot position is not just the Estia case, which had to do with the fact that the UK could not develop colonies. I think the Cypriot position is also focused, or should be focused, on Appendix P of the 1960 treaties with regard to the future of SBAs. As you probably know, there it is clearly stated by an exchange, again, of correspondence between Makarios Kouchouk on one side and the UK on the other side, that in case in the future the UK, and here of course you're going to tell me yes, by applying its sovereignty, will decide that they would not need anymore for military purposes the bases, then the only state to which they can give the basis is the Republic of Cyprus. So there is no right of abutendi, which is the gerundium of giving away the property in this case. So we can argue, obviously, that by that declaration, the UK divested its full sovereignty rights. And there I joined the court in the Estia case, where it clearly said that it's an amalgamate of separate rights and not anything full in terms of sovereignty. Thank you. So sorry for being so long. So if Nasia can comment on this, I would be grateful. Sorry. Thank you.
Unmute. Okay. Thank you, Sosos. Please mute yourself. I think we will give the floor to Nasia, and then maybe Mr. Kiris would like to add something on the Halumi, and maybe Chagos then. Yes. So Nasia, we are listening to you.
Thank you very much, Soso, for giving me some of the gaps I left in my presentation. I don't agree with you that Appendix P is relevant. And again, I agree with you that Appendix P says if the UK decides to withdraw from part of the SPA or from the SPA as a whole, then that part or the SPAs themselves need to go to the Republic of Cyprus and cannot be given to any other state. I don't disagree with that, but that is not incompatible with the view that the SPAs are colonies, because if it's clear now in international law that if there is a colony out there, then it should be, when the colonization takes place, it should be given to its rightful owners. Yes, the people who are exercising the right of self-determination. So even if one conceptualizes the SPAs solely as colonies, Appendix P makes sense. It's just the, if you want, the implementation, the idea that I've already explained, that there is no one else to take the SPAs and make them their own, other than the Republic of Cyprus. So the fact that the Appendix P is referred to doesn't really change the argument. You're right that it potentially suggests that the UK's sovereign rights are not as extensive as they once were, but that doesn't stop it from being a colony. Yes, that was just my comment. The others were observations from sources with which I agree.
Please, thank you. Thank you, Nasia. I'm not sure whether everyone could hear you very well. For us, it was a little bit difficult to follow you. Hopefully, the others were okay. Thank you also from Sosos. Now, do you have something to add on this point? And then we can go to the use of foreign experts. So, yes, so before we go to the use of foreign experts, do you have something to add on this point? Okay, good. And then we go to
thank you to Sosos for his comments, which are well made. I just want to reinforce something that Nasia said in relation to the judgment at the Supreme Court of the United Kingdom in the case of the Crown on the application of Bashir and the Secretary of State for the Home Department. First of all, it's a sign of the constitutional significance of this case that instead of the normal 5 Supreme Court justices, 7 Supreme Court justices sat in on that case, presided over by Lady Hale. And all 7 justices, Lady Hale, Lord Mance, Lord Kerr, Lord Wilson, Lord Sumption, Lord Reid and Lord Carnworth, reached the same conclusion. So that adds additional weight to the judgment. The second point I wanted to make in relation to the Bashir case was that the argument put forward by the Home Secretary on behalf of the British government was in my judgment, or in my assessment, a preposterous argument. The argument was that the sovereign base areas were entirely new entities created in international law in 1960. This appears in paragraph 62 of the judgment and also in the lower court decisions. I was a PhD student, and in my PhD thesis, if I can say this, I quoted Halsbury's Laws of England. This was 25 years ago. Halsbury's Laws of England made it quite clear that in 1960, what the United Kingdom ended up retaining as far as the constitutional law of the United Kingdom was concerned were the remaining portions of the Crown Colony of Cyprus. When did the Crown Colony of Cyprus come into existence? Well, ceremonially, the Crown Colony of Cyprus came into existence in 1925, when by order in council, or letters patent, by letters patent, the then king conveyed this ceremonial title. But it was just a ceremonial title of Crown Colony. The island of Cyprus became a small c colony of the Crown in 1914 upon the annexation of the island of Cyprus under the Annexation Order in Council of the 5th of November 1914. And it was on that moment, on the 5th of November 1914, that the British acquired sovereignty over the island of Cyprus, and the island became a small c colony. It became a crown colony with capital C's in 1925. And that is in Halsbury's Laws of England. And I could not understand why the Home Secretary in the Bashir case was trying to put forward this preposterous argument that they were new entities. And the Supreme Court of the United Kingdom, together with the Court of Appeal, and at least one of the judges in the Sovereign Base Areas Court, saw through the argument of the Home Secretary. And we now have this phenomenally important judgment of the Supreme Court of the United Kingdom that makes it absolutely clear that the sovereign base areas, despite their name, constitute the remnants of the Crown Colony of Cyprus. And that's why they should be called the remnants of the Crown Colony of Cyprus rather than sovereign base areas.
So, yes.
Does the attorney?
Yes. Mr. Philidis, would you like to comment on this topic, or should we move on to the need for external advice from experts, legal experts, not necessarily from abroad, in cases such as Halloumi or Brexit or any others? Thank you.
Yes. I would like to thank Soros for his useful remarks. Well, regarding the case of Halloumi, I must say that when I took office, the procedure was already on its way, and people had been already appointed and working on it. But the idea of employing and using local experts, of course, is welcome. Is something really useful. In practice, I must say that during my term, we used the services of many local experts, including Stephanie, Nasia, and other from the private sectors, lawyers who assisted the Republic. Just to break the seriousness of the discussion regarding Halloumi, one of the problems, practical problems, was the ingredients or specifications. And during a meeting, we had a very formal meeting, I must say, the problem arose as to the practicality, because according to the specifications we put forward, about 50% of the milk to be used for Halloumi must be from goat milk. And I must say that some people were protesting there at the meeting because we don't have enough goats to have so much milk so as to produce Halloumi. And also the fact is that we cannot import any more goats because they have to be locally bred. So one of the participants put forward the idea to overcome this problem, to import many goats from abroad and to give them Cypriot passports. This is just to break the seriousness of the discussion. Thank you very much.
Thank you, Mr. Cleridis. Now, if you don't mind, I will take the microphone. We have a couple of more questions from a student of ours, Eva. I will summarize, Eva, but I don't think that your questions should only be addressed to Chagos. Actually, your questions are very interesting for our three speakers. So listen to this, I'll try to be brief. Eva is saying that, of course, following Chagos's very thorough explanation of what is segregation, Eva would like to invite our speakers to think about the separation of the communities on the island of Cyprus and within the Republic of Cyprus, and whether the SBAs could be regarding as further supporting the lack of equality between the citizens of Cyprus. So this is a very valid question from a young student. Once more, thank you for this. And she says, if so, her second question is, instead of referring to Cyprus as we the people of Cyprus, could we refer to we the people of the SBAs and the rest of Cyprus? And could such a concept continue the spread of the cracks in the Cypriot constitution and its citizens? Thank you, Eva, for this. So I'm sure that all three speakers have things to say. Who should I start with? My right, my left. Okay, Claire.
Yes, I'm grateful to Eva for her question. It's quite a sophisticated one. I will go back to first principles. What occurred in 1960 holistically was, first of all, the geographical partition of the island of Cyprus, or to use the word that was used in the advisory opinion of the International Court of Justice, the detachment of two parts of the island of Cyprus from what became the Republic of Cyprus. So we had a partition in 1960 of a geographical nature. The way to understand that is that in 1956, the British came up with this idea of a trizonal partition with British, Turkish and Greek zones. The Americans objected to it with the Eisenhower administration. The chiefs of staff objected to it, and Governor Harding, for all of his faults, objected to it. And for various reasons, there was no fully fledged trizonal partition in 1960. We ended up with the sovereign base areas peeling away from what became the Republic. Now, the question is, therefore, whether the people of the Republic of Cyprus came into existence in 1960, notwithstanding the absence of the words "the people" in the 1960 Constitution. The British government did recognise the existence of the people. For example, in the Macmillan Statement of 19th of June 1958, when Harold Macmillan presented the Macmillan Plan, he highlighted the two communities while simultaneously referring to the concept of the people. So the idea of the people, I would suggest, exists notwithstanding the geographical partition of 1960 and notwithstanding the constitutional segregation imposed in 1960. Now that raises the question, if the people of the Republic of Cyprus do exist, whether the people encompass the citizens of the Republic of Cyprus who inhabit the sovereign base areas. I would suggest that they do. This also raises the question, which Sozos has discussed with me, I think he's more of an expert on this than I am, as to whether the sovereign base areas have a people associated to them. I would suggest that there is no people of the sovereign base areas as such. There are residents of a temporary nature and there are residents of a permanent nature. Now, as far as the future is concerned, that's in the hands of the negotiators. I don't want to discuss that. It's outside the framework of 1960. But Eva's raised a very important point, We had a constitutional partition in 1960. We had a geographical partition in 1960. Both of those partitions were encased in the form of the law, whether they were morally appropriate or not, or legally appropriate from the standpoint of international law is another matter. And the de facto segregation that we subsequently saw in 1974 is precisely that, a de facto segregation and partition. So we need to think of three partitions, actually. The constitutional partition of 1960, the geographical partition of 1960, and the geographical partition of 1974. The difference being that in 1960 there was a geographical partition of the island of Cyprus, whereas in 1974 there was a de facto partition of the Republic of Cyprus, which is the entity established within the island of Cyprus. And both the Cyprus Act of 1960 and the Treaty of Establishment of 1960 draw a clear distinction between the island of Cyprus on the one hand and the Republic of Cyprus on the other.
Thank you, Claire. On this note, yes, I will go.
I fully agree. I don't have anything to add. Thank you.
Okay, on this note, I just wanted to say before I was going to give the floor to the other speakers that I put in the chat a brief blog post. No, it's not that brief actually. A blog post which was written here at the Law School of Euclid, Cyprus. It's on a comparison of the islands of Cyprus and the islands of Great Britain and the relations in times of COVID-19. And I think it's a good background reading, simple background reading, not replacing, of course, further deeper reading. But if you would like to get, a quick grasp of what we are discussing now. Mr. Kiris just said that he didn't have anything to add at this point, and I know that Nasia wants to add something and has to go soon. So, Zora, can you please mute us so that Nasia can start talking? Thank you.
Stephanie, can you hear me? Okay, great. So to answer Eva's question, yes, I think the creation of the SBAs created inequality and discrimination in Cyprus. I'm not going to go back to the basics like Claire has did. I'm just going to stick to the law, which states that people who are Cypriots who are living in the SBAs do not have the right to vote for the administrator of the SBAs, who is the person who is making the laws of the SBAs that they have to comply with. I mean, it might be easy to forget that the SBAs are an entirely different jurisdiction to the Republic of Cyprus. If someone is in the SBAs, they don't comply with Republic of Cyprus law, they comply with SBA ordinances that are drafted by the administrator, yet that person is not voted. And it's for this reason that the UK government has not signed and ratified Protocol number 1 of the European Convention on Human Rights, which in relation to the SBAs, which protects the right to vote. The other reason it has not satisfied it's because the same protocol protects the right to property, which is again limited in the SBAs because people who have property in the SBAs are not allowed to develop it as they want. Theoretically, that is what the non-military development agreement that we made reference to before is supposed to fix, but that has not happened yet. So there is definitely inequality there, without a doubt, and it's something that should be addressed. I don't know how. As to the second question, whether we should be talking about the people of the SBA, I will agree with Claire was that no, we shouldn't. But I'm not sure I agree with the statement in the comments that the SBAs cannot have a permanent population. As a matter of fact, they do have a permanent population. There are people who live there, Cypriots who live there for their whole lives. They are, by definition, part of the permanent population. Yes, the soldiers are not permanently there, but they're not the only residents of the SBAs. That's all I wanted to say. I want to thank you very much. I have to run. Thank you for hosting me. Bye.
So thank you, Nasia. She had to go. We thank her very much. I think we all agree, and Nasia, Sozos, Chagos, and myself have all written on the SBAs, on the status of the SBAs, whether from a public international law perspective, EU law perspective, UK perspective, but also historical perspective. So if you would like to know more about this, we can always, put in the chat, or you can get in touch with us. Now, Mr. Kedis, at this point, do you have something else to add, or should I conclude?
No, please.
Yes? Okay, Claire, the same, I think. Okay, so it's time to conclude, and of course, I can't, replace or I can't even try or attempt to summarize everything that was said tonight. I think it was extremely useful, extremely deep, very high level. But having the questions of Judge Arestis in mind, the one he put to us, and I think we have largely answered. I just wanted to share with you some of my thoughts, some of what I will take away with me from tonight. And perhaps food for thought for further symposia, because as you understood it, we are eager to have further symposia in related fields. So it's clear that the intrinsic link between the historical constitutional foundations of the Republic of Cyprus and contemporary legal and political challenges are one of the main obstacles at the national and the international level. So if we don't address those intertwines, then obviously we don't have an answer as to who we are, where we come from, and where we go. And this is probably one of the biggest issues the Republic of Cyprus has. Now, think about 60 years in terms of our lifespan. 60 years is, middle age crisis, or it's so the Republic of Cyprus is, after all, not an old lady and not perhaps a very mature lady. So it only makes sense that we are discussing what we're discussing, but it also makes sense that it's very important to reflect on our roots, common roots, shared cultural heritage. We spoke a lot about language, we spoke a lot about religion, but yet it was a legal symposium. So we need to reflect together on our roots, and we need to understand together what it is that we want. Mr. Kleridis gave us some insights and some suggestions as to what it is that we could demand from a more democratic and more transparent society. And I think that this is to be welcome. In particular, when you think about, issues such as the Cyprus problem, but not only, the struggle that Cyprus had to undergo in terms of the financial crisis, or the current struggle in terms of the pandemic, are again examples of situations where, if we don't know who we are, where we come from, and where we go, we don't know how to address those situations properly. So it's a little bit the message that is in that blog post that you were given. Then I would like to think about the role of the Republic of Cyprus in a post-Brexit European Union. And this is something I think the institutions in Cyprus, or the organs of the Republic, are not sufficiently conscious of, or it's not sufficiently debated, including at the democratic level. So I think we have a role to play here with the academics, with the high-level professionals, and the wise men of this island. There aren't that many wise men and women. When I say men, I also mean women, obviously. So the role of the Republic of Cyprus in a post-Brexit EU, and we will have probably some webinars in that aspect. And then I would like to come back to what Mr. Clery spoke about, which is basically the strengthening of the institutional capacity building on this island. At the level of the various branches of government. And a keyword which we have not mentioned tonight, although it was implicit, upholding the rule of law and the principles of good governance. So we probably will come back to this again, because what we are serving and what we are aiming all to serve is the rule of law. So this is why the role of the independent officers of the Republic and organs of the state is so crucial. So I see that there are some comments in the chat, but they are more thank you notes and comments on the quality of what you have all heard. It's very nice to have you all with us, and we would like to thank you on behalf of the speakers here, and Zora who is here as well, and Ms. Gladys who is here with us. Thank you so much for having been with us. We finish on time. We're happy about this. I would like to wish those of you who are not in the comforts of your homes a safe journey, because there are a few people who are not home apart from us. So we thank you very much, Mr. Kairis. Kerke, we thank you very much. Nasia is gone, but we thank you very much. Judge Arestis as well. And we hope to see you soon again. Thank you. Keep an eye on the MS Tips folder. Thank you. Bye.
Thank you, sir.
Thank you.